Having recounted some of the crazy adventures in which I was involved, it occurred to me that it might be helpful to young lawyers um, to hear some advice, if you will, that I can give on practicing. And number one is don't always believe your client. Your client may not even know that he or she is misrepresenting. It's just the way they express things. Um, One word may mean something to the client, it may mean something else to you. So make sure that you get into the details and verify them very carefully. A lot of these misadventures I had, which I've recounted, stemmed in part from the client not really expressing his or her intention correctly. Secondly, always read everything very thoroughly. There is a temptation, to which I succumbed occasionally, to just scan an agreement because you've seen that same sort of thing before. There could well be changes that are of significance. So, as boring as it might be, read all documents very carefully, including the boilerplate. Third, I would advise that you thoroughly vet, if you will, your client. Not that the person introduced you or referred to you as dishonest or anything else, but you want to get the entire background of the client and his or her business. So you are much better equipped to provide service to them. If you're a good lawyer, you will perceive some opportunities for the client and his or her business that may not have been recognized by the client. In my experience, reviewing a company or a business from top to bottom or bottom to top is the best way to get a thorough understanding of the client's business. I usually told the client when first I met them that I wanted to deconstruct the business completely and start from ground zero and build it up the way the client did, and then show the client how it could have been built or maybe should be built to achieve the client's goals. When the client comes to you, they're set on a structure and it never occurred to them to change it. They think it's complicated, time-consuming, expensive. It may be all the above, but it is very worthwhile to show the client various opportunities that he or she can take advantage of by restructuring. In connection with that restructuring, I always recommended that the client establish separate subsidiaries, LLCs, corporations, what have you, for various aspects of the business. That enables the client to take advantage of various product lines that may be doing well, to isolate intellectual property in one company so it's not subject to creditors should something terrible happen. And that has proved to be quite successful over the years. So you may have a holding company, holding LLC, and beneath that, several different sub-LLCs, if you will, for various products, for intellectual property, and for other purposes. A service company, for instance, where all the administration will lie and it will service the other subsidiaries and the primary company. In the case of intellectual property, that could reside in one subsidiary, and then it would license the appropriate company, be it a subsidiary or the main company, to produce, promote, commercialize a particular product, and the patent lawyers can advise on that. although that's time consuming and expensive. And that kind of structure really helps going forward. It helps in audits because they're directed towards one company. All product lines aren't commingled in one company, and hard to differentiate between costs for products and other accounting attributes. It has, as I said, it has proven to be very beneficial to clients over the years. So I'd strongly recommend that you take a look at that approach. Lastly, I would recommend that you insist that your client give you all information about a business or the client at his or her disposal that's relevant to the matter, or that could be relevant to the matter at hand. Clients, as we all do, I guess, sometimes think, oh, well, that doesn't matter, or that's not relevant, when in fact, individual pieces of information could be relevant. That's for you to decide, and it's your responsibility to decide. After all, you are responsible for the end result and any negative things that happen along the way attributable to the fact that you didn't have all the facts is really your problem. Granted, the client may not have revealed matters to you or individual facts, but it's for you to ferret them out and feel satisfied that the client has told you everything. Granted, maybe the client has not, and there's no way to be absolutely sure, but repeatedly reviewing matters with the client is very helpful, because sometimes you will get variations on the facts that should key you to the client maybe not quite understanding what you're asking, and so you need to ask it in a different way, or your client hiding a fact that he or she may not know is even relevant. Hiding doesn't necessarily mean a negative, criminal, if you will, intent. It's just that they dismiss it. Clients tend to feel that many things are not relevant. Oh, why would the lawyer want to know? What's that have to do with it? Get all the facts, all the issues out on the table so that you can sift through them and put them back together in a way that makes sense for your project. That really is the most important service you can do to your client. Oh, I meant to say that's the most important service you can do for your client, not do to your client. In any event, I should add one more thing, and it concerns the international practice. If you are involved with a consortium, as I have been, with many different countries involved and different languages, make absolutely sure that everyone around the table understands the meaning of the language you're using in a written contract or in spoken negotiation or in any other manner. Because people tend to think, who are proficient, let's say, in English, that they understand the meaning of words. Most English speakers don't understand the meaning of words, let alone people whose native language is not English. So the way to verify that, and which I have used many, many times, is to pose examples. As I've said, I was involved in a consortium in Central Asia where there were, 6, 8 nations involved, and as many languages. And all the people around the table spoke excellent English. And one sitting in would assume that certainly they understood. Well, that isn't always the case. So on any particular significant issue, I would give an example to everyone around the table and say, now, under the contract, what would the result be from the facts I just gave you? Would that be in accordance with the contract? Would it not be? What would happen if it weren't? Etc. And I'd go around the table and get the views of each person. And invariably, I got someone who was way off. And in talking to him or her, I ascertained that that person really didn't understand the full scope of the meaning of the English terms used. I am the first one to say that English is not the best language. It's a very difficult language. But you have to make sure that everyone really understands the meaning, because the conduct under the contract will be determined by the contract. And usually the contracts I did provided that the English language shall prevail. Many times we did contracts in dual languages. I've done contracts in Russian and English and Chinese and English. And actually the page was bifurcated. One side was the English, one side was the Chinese, for example. But it always provided that English prevailed, and London was the default court. So when you find someone that's really off-center on the meaning of a particular phrase or provision and how that operates under the contract, you must take them aside with a translator and explain how you meant the phrase to operate. And after discussion, usually that person comes around to a very good understanding. But don't assume because they speak English like somebody from Iowa that they understand the scope and meaning of the words used. That will take you into territory into which you don't want to go. So use the device, I'm suggesting, of an example. Pick a provision in the contract, make up facts related to it, and ask, now, how do you interpret that? Is that a breach? Is it not a breach? What does that provision mean? What do you have to do under that provision? And then get the answers around the table, or individually. You can take them aside so they don't get embarrassed if in fact they're really wrong. That proved to be a very useful device in my dealings in other countries, and I think prevented a lot of difficulties.